Welcome back to this third segment of the Introduction to Land Law. We are carrying on, of course, in the same vein as looking at what the basis for the rest of our lectures will look like. So we are not necessarily doing this introduction on the basis of the standard Introduction to Land Law and the depth that is usually required, which you undoubtedly can read from a textbook. This introduction focuses on the basis on which all the other lectures will return, for example, for definitions and so on. So the introduction looks at the basis of certain aspects of land law, in particular, what and where do the principles derive? Where do the principles derive from? And we see a lot of the land law principles are based on statute. There are various pieces of legislation which are necessary to know and to understand in order to be able to understand land law. Now, the Law of Property Act 1925 is going to be the biggest piece of legislation which is necessary to have some grasp of in dealing with land law issues. Now, in 1925, there's a raft of legislation which deal with property, not least the LPA 1925, but also the Land Registration Act 1925, the Land Charges Act 1925, the Administration of Estate Act 1925, and we see that these pieces of legislation came on board to deal with property. Now, the question is, when we look at land law, what are the definitions for the types of principles that we will consider? So, for example, what is the definition of land as opposed to, say, chattel? Well, dealing with the latter first, chattel is personal property. And personal property, to the extent that you're dealing with tangible personal property, like a laptop, for example, or intangible personal property, such as the balance in a bank account, because the balance in your bank account is not necessarily tangible, it is intangible because you're looking at a shows in action. But when you come to look at land, the question is, what is it? What is it that we are talking about? Now, in the previous segments, I pointed you to an estate, and I said to you, well, you don't necessarily own land, the particular thing, but what you own is an estate in land. But what is it that I'm saying that you don't own? And what is it that I'm saying it is that the Crown owns? Well, if we consider a piece of land, for example, let's call it Blackacre. And if you imagine on that piece of land, you have a house, there are trees, your next door neighbor has the right to walk across that piece of land, for example, and there is a stream running through that land. Well, it is anything on that land, and based on what I've just gone through, it is anything above the surface. So, for example, it talks about going upward and going towards the sky. Now, that is, of course, subject to the Civil Aviation Act 1972. So, albeit that you own whatever is on your land from the ground up, you can't, for example, start telling British Airways that they can't fly over your house because that's your land and they have to pay you for it. Unfortunately, you can't do that. But legally, you own that land going all the way up. You also own what is on the surface itself. So the ground, the stones, the grass, you own that as part of the definition of land. You also own anything going below the surface. Now, in an interesting situation, it used to be that what was called treasure trove used to, albeit if you found it on your land, it used to be that if you found treasure on your land, and this used to be anything defined as over 300 years old, for example, would actually belong to the Crown, because again, that was part and parcel of the land ownership rights of the Crown. But we've seen, of course, that statute has kicked in, and that is not the way it is now. The Treasure Trove Act of 1996, outside of this syllabus of land law, does say, for example, that you as the person who owning the estate can have that right. But it is anything going below the surface is also yours. Again, there is a modification to this going below the surface. And that modification, of course, is again in statute, and it is subject to the Coal Industry Act of 1987 to suggest what you can own going down below the surface. So, the other thing you own, of course, are some fancy land law words called corporeal hereditaments and incorporeal hereditaments. It is at this point that land law students start thinking, oh my goodness, this is just too much. Well, it's not. As long as you know what a hereditament is and what it is when it is corporeal or incorporeal, you'll be fine. So if we look at, for example, what the meanings of these are, I want to pause for a minute and say to you that lawyers do tend to subscribe sometimes. Now, let me qualify that. Some lawyers subscribe to the theory that the only thing that the client should understand is your bill. Well, make of that what you may. So if you use words like corporeal hereditaments and incorporeal hereditaments, then you are on track. But all they mean is simply this. When you're looking at corporeal, it simply means tangible, real property. So I've already told you about the surface, going up through the air, going down through the ground. But what we're considering here is, for example, the house that's on the property or the tree that's on the property. So the buildings and trees will amount to corporeal hereditaments, things you can see and touch. Incorporeal are the less tangible rights. For example, if there's an easement across the property or if there's a covenant, these, of course, are also part of the definition of land. So if you assume for a moment that X holds the estate in fee simple absolute in possession in Blackacre, there are other persons who can have a lesser interest in and over Blackacre at the same time that X owns Blackacre. So for example, if Mr. White, who owns Whiteacre next door to X's land, and he's X's neighbor, he owns Whiteacre and he may have a right of way across Blackacre. So he may be using a path across Blackacre as a shortcut to get to the pub, for example. Now ABC Bank may have lent money to X using Blackacre as security for a loan. Now ABC Bank would have an interest in Blackacre based on the mortgage, because when money is used as security on property, it is generally a mortgage, as we will expand in a later lecture. Y, who is X's partner, may have contributed money to the purchase price of Blackacre, and therefore Y may have an interest under a trust, for example, if the property was purchased in X's name alone. Now, all of these persons may legitimately claim some kind of interest in or over Blackacre. Now, these interests I have just mentioned may be legal or they may be equitable. Now again, this introduction is to allow you some degree of understanding of land law. In order to properly understand land law, there are sort of various levels that you must get to grasp with. And one level, of course, is determining legal rights and equitable rights. Or you might see them termed legal interests and equitable interests. So, when I've looked at the type of interest there, Y's interest under a trust, for example, ABC's bank loan, which is a mortgage, Y may have an equitable interest under a trust, and ABC Bank may have a legal interest in respect of a mortgage. So what do we mean when we talk about legal and equitable rights and interests? Well, legal interests are dealt with differently from equitable interests. And what makes it a legal or equitable interest is defined by the legal rules and requirements for that interest. So whenever you are approaching a land law question, you need to determine, first of all, what is the interest? Then you need to determine what type of interest is it? Is it equitable or is it legal? And the last thing to determine is it registered or unregistered land? If you follow that 3-stage test, you cannot go wrong in a land law exam. You simply cannot. So, an easement may be a legal or equitable right. It just depends on whether it meets the requisite criteria. So what makes it legal or equitable is defined by law. So a lease may be legal or equitable, again, depending on whether it meets the requirements for a legal or an equitable lease. If you really want to crack land law, as I said, and I will give you the simple code, it is again the 3 things. Does the right meet the criteria? So is it a lease? So you need to know what a lease is. So is the thing that you're looking at, the fact that the examiner tells you that A allowed B into possession for 2 years and B was paying £50 a month for argument's sake, does that make it a lease? Do not get confused by looking at, is it a legal lease? You need to determine first, is it a lease? Equally, is it an easement? Does it meet the requirements for adverse possession? Once you do that, you then look at, is the right legal or equitable? Is it a legal lease or a legal easement? Is it an equitable lease or an equitable easement? And lastly, of course, you look at whether it is registered land or unregistered land. As we review the session topics, whatever they are, I will ask you to consider that checklist. And generally, if you apply that checklist, you generally cannot go wrong. We will, of course, consider the criteria for the various topics when we review the sessions. So when we do lease, for example, and when we do easement, we look at the criteria for those and so on. Well, what about interests, legal interests, and equitable interests? What are they? How do you look at them? I will pause here, and when we come back from the break, we'll finish up with this introduction, and certainly you will understand a little bit more about the background and basis of land law that will allow us to certainly be able to deal with the topics in the later lectures.